On December 14th, 2017, Andrew Grimm parked his Honda Accord on a side street of downtown Portland, Oregon. Grimm used a parking app to pay for parking from 5:41 p.m. to 7 p.m. 7 days later, on December 21st, Grimm's car was towed from the roadside parking spot by the city of Portland. Grimm filed a complaint in court alleging that the city violated his rights under the 14th Amendment's Due Process Clause. This week, I want to talk about Grimm versus the city of Portland, a 2025 Ninth Circuit decision involving notifications before vehicles are removed. I'm Steve Serbalik, and I'm a panel attorney with ASCOPS in Arizona. Grimm's complaint was that the city of Portland violated his rights by not granting him due process. Simply put, Grimm said that he was never notified that his vehicle was subject to removal, being towed, and he should have been given the opportunity to move his own car. Portland, however, said that he was given plenty of notice. Remember, Grimm parked his car on December 14th. Portland noted that on December 15th, a city parking enforcement officer issued 2 citations and placed them on the windshield of the vehicle. 1 citation for being parked in a meter zone without proof of payment, and 1 citation for displaying out-of-date registration tags. Then, on December 19th, another citation was issued for parking unlawfully and placed with the other citations. The same day, the officer placed a red slip on the car warning the vehicle would be towed if it was not moved. Finally, on December 21st, an officer issued a final citation and placed it with the other citations. The officer then placed another red slip with a tow order and contacted a towing service, which removed the car. After the car was towed, the city mailed a tow notice to the address listed on the car's registration with instructions on how to retrieve the car. Grimm never returned to the car or saw the citations or red slips before the vehicle was towed. He picked up the vehicle from the towing service and paid $514 to do so. The Ninth Circuit recognized that under Clement versus City of Glendale, governments must provide notice in most circumstances before towing an illegally parked car. So the question became, were the citations and red slips placed on the car enough notice, given that Grimm never returned to the vehicle and saw the notices? The court held that the requirements under the 14th Amendment had been met by the city. In this case, the tickets served as adequate warning that the vehicle was illegally parked, and the first red slip was a cherry on top that made it clear that the consequences of the parking violation was that the car would be towed if not moved. There's no requirement to actively track down the owner, to go to his home, call him, or mail him a notice, specifically because the removal of the car would only temporarily deprive Grimm of his property. The standard would rise if the property removal would permanently deprive Grimm of his car. This strikes a balance between the interests of the state to not allow cars to remain parked illegally and the vehicle owner to have access to their car. So, if you, the law enforcement officer, want to go out of your way to look up an owner and give them a phone call before towing, go for it. You'd be going above and beyond what is legally required of you. But there is no requirement to track down owners who leave vehicles unattended and parked illegally. Most agencies have standard practices or policies for when officers leave a notice and come back a few days later to tow the car if it's still there. The Ninth Circuit affirmed that this practice is lawful and correct. So keep it up. If you have any questions or comments on this topic, please leave them in the comment section below the video. Please like this video, follow the channel, and turn on notifications. It helps show these videos to more interested officers. Be on the lookout for new videos. They come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Serbalik. Thanks for watching and stay safe out there.
Call back for 86. Negative.